Section 1. Abuse Neglect Proceeding. In Part 2 of your training, we will review the 3 types of proceedings with which a guardian ad litem must be familiar. These include abuse and neglect proceedings, the child in need of supervision proceedings, and delinquency proceedings. As cases are assigned to you, review the applicable section of your handbook for the type of proceeding involved to ensure that you are completely familiar with all relevant rules, case law, and court requirements. The handbook provided to you with this training contains thorough checklists at the start of each section which are relevant to the particular type of proceeding to be discussed. Using the checklist provided for the appropriate type of proceeding will prove invaluable in assuring complete and thorough representation for your client. Section 1 deals with abuse and neglect proceedings. As a GAL, this is the most common proceeding in which you will participate. It is very likely that you will be involved in this type of case, so it is important that you become familiar with all facets of it, from the myriad of hearings to implications of case law. We will look at those facets as well as examining how a child may respond when abused, the family dynamics which can cause these incidents, and aspects of visitation when a child must be removed from the home. In Wyoming, your responsibility as a guardian ad litem is to represent your clients in a hybrid role in abuse and neglect, TPR, and appellate proceedings. This means that you must represent the child's wishes as well as the child's best interest at the same time. If you counsel the child appropriately and effectively, then the majority of the time the child's wishes and the child's best interests will align. Wyoming Statute Section 14-3-211A sets forth this right of the child to representation by a hybrid model GAL. It states, "The court shall appoint counsel to represent any child in a court proceeding in which the child is alleged to be abused or neglected. Any attorney representing a child under this section shall also serve as the child's guardian ad litem unless a guardian ad litem has been appointed by the court. The attorney or guardian ad litem shall be charged with representation of the child's best interest." While it is your job to represent the child's best interest, it is important that you do not ignore the child's wishes, even if his wishes are contrary to what you think is best for him. If the situation arises where you and the child disagree, you should consider whether it is necessary or appropriate to appoint an attorney to represent the child's direct wishes. Let's take a moment to review how an abuse or neglect case gets to juvenile court. First, a report of suspected neglect is filed with the Child Protection Agency or law enforcement. Wyoming law mandates that every person suspected of child abuse or neglect must be reported. Knowingly making a false report is a misdemeanor. Once a report is received, Wyoming's Department of Family Services must initiate an investigation or assessment of the report within 24 hours. An investigation is initiated when the report indicates that criminal charges could be filed for the alleged conduct, or when the child is in imminent danger and it is likely the child will be removed from the home, or when there is an alleged child fatality, major injury, or sexual abuse. If those circumstances do not exist, then instead of an investigation, an assessment may be initiated. During the investigation, DFS will make risk and safety assessments to determine whether there is a risk of maltreatment, whether the child is safe in the home, and whether the child needs to be removed from the home due to unresolvable safety issues. At the conclusion of the investigation or assessment, DFS will determine whether the report of abuse and/or neglect is substantiated or unsubstantiated. If the report is substantiated, the parent may be listed on the Central Registry. Placement on the Central Registry is administered outside of juvenile court, and a parent can be placed on the registry even if not adjudicated in court. This registry is confidential and maintained by DFS. If it is found to be necessary, the child may be taken into protective custody. Wyoming statute grants only 3 bodies with the authority to take a child into protective custody: the police, a medical professional, or the court. Law enforcement officers have this authority whenever there are reasonable grounds to believe a child has been abandoned or lost, if he suffers from illness or injury, or if he is endangered by his surroundings. Officers of the law may also take a child into protective custody if the child's conduct or behavior is a danger to himself. A physician, physician's assistant, or a nurse practitioner may place the child in protective custody if he or she believes the child's life, health, or safety is in imminent danger, and whether or not additional medical treatment is necessary. The court can continue protective custody after making a finding at a shelter care or initial hearing that there is reasonable cause to believe that a child has been abused or neglected, and that by returning the child to his current home or placement is contrary to the welfare of the child. Temporary protective custody cannot exceed 48 hours, excluding weekends and legal holidays. Once a child is taken into protective custody, DFS must be notified immediately, and custody must be transferred to DFS as soon as possible. At that time, DFS has several responsibilities. It must accept physical custody of the child and make efforts to inform the parents of the protective custody. This includes notifying the non-custodial parent, which is called a diligence search. DFS also initiates an investigation, assesses the child's mental and physical health needs, and arranges for her education. Finally, DFS arranges for the child's care in the most appropriate and least restrictive setting that will meet her needs. DFS may place a child with a non-custodial parent, extended family, a foster home, or other certified child care facility. DFS must start a diligence search for all adult relatives at this time as well, and notify the relatives within 30 days that the child has been taken into custody and that they can be a placement resource. Prior to placing a child with a non-custodial parent or extended family member, DFS must determine whether anyone in the home has been convicted of a crime involving serious harm to children or has been substantiated for abuse or neglect. DFS is required to notify the district or county attorney as soon as possible after a protective custody has been taken. The district or county attorney then determines whether the protective custody should stand or be released. If the child is released from protective custody, then no case will be filed in juvenile court. If protective custody is taken and the district or county attorney does not release the child, the district or county attorney is required to promptly file and present to the court a petition alleging abuse and/or neglect. This petition starts the legal proceedings in juvenile court. Now we will review the succession of court proceedings, statutes, and hearings that are set in motion when the petition is filed. The petition, which alleges abuse or neglect, or both, will also contain the necessary jurisdictional information. Keep in mind that a petition can be filed even if protective custody hasn't been taken. This may occur if the district attorney has sufficient information leading him to believe that a child has been abused or neglected. After the petition is filed, the court must issue an order to appear to the respondents in the petition, as well as any non-custodial parents or putative fathers. Service of the order to appear must be made in accordance with Wyoming statute. If a parent fails to appear at the hearing after proper notice, the parent can be held in contempt of court and a bench warrant for the parent may be issued. Wyoming state statute defines both of the terms abuse and neglect in section 14-3-202. You should be intimately familiar with these definitions. When a child is taken into protective custody, a shelter care hearing must be held within 48 hours. This time frame excludes weekends and holidays. The purpose of this hearing is to determine whether continued shelter care is required to protect the child's welfare pending further proceedings. For continued shelter care to be ordered, the court must find that returning the child to the home is contrary to the welfare of the child. If the court finds this to be true, the child is placed into the custody of DFS. If not, the court may release the child to the custody of his parents but may impose a number of conditions upon the family. At the shelter care hearing, the court is also required to advise the child and parents of a number of things, including the contents of the petition and any allegations made. Further, the court must advise the parents and child of their rights in the juvenile court system and the state's obligation to file a petition to terminate the parents' rights if the child remains in foster care for 15 of the most recent 22 months. Any party to a juvenile court proceeding has the right to a copy of the allegations against him. He has the right to confront and cross-examine witnesses, to introduce evidence, and present witnesses on his own behalf. Furthermore, he has the right to use the court's subpoena power to compel witnesses to testify or produce evidence, and he has the right to a jury trial. Any and all relevant and material evidence which would be helpful to the court in determining whether shelter care is necessary is admissible, even if it would not be considered competent in an adjudicatory hearing. As you are working through facets of the shelter care hearing, don't forget about the Title IV-E required findings at this hearing and other federal law requirements, such as the Indian Child Welfare Act, the Adoption and Safe Families Act, and the Fostering Connections Act. In addition to the shelter care hearing, respondents must also appear at an initial hearing which may follow the shelter care hearing or may be held at the same time as the shelter care hearing. At the initial hearing, the court must advise the respondents of their rights under the law, the specific allegations in the petition, and that the respondent may be responsible for child support of the child. The purpose of the initial hearing is to give the respondents the opportunity to admit or deny the allegations in the petition. If the respondent admits to the allegations, the court adjudicates the child as abused and/or neglected and proceeds. If the respondent denies the allegations, the court sets an adjudication hearing within 60 days or, at the latest, within 90 days from the date that the petition was filed. As mentioned earlier, the shelter and initial hearings can also be held together. If the parent denies the allegations in the petition, then an adjudicatory hearing is held. If the parent admits at the shelter care initial hearing, the next step in the process is a dispositional hearing. If the respondent admits to the allegations, he must lay a factual basis for the allegations. In other words, he must state on the record what he did that constituted abuse or neglect of the child. There may also be a consent decree or stipulation, which we will discuss later. The adjudicatory hearing is the trial on the allegations contained in the petition. The adjudicatory hearing can be to the bench or to a jury. The state has the burden to prove the allegations by a preponderance of the evidence. Only competent, relevant, and material evidence is admissible at the adjudicatory hearing. If a party wants a jury trial, he must request it within 10 days of the initial hearing. This hearing must be set within 60 days, or for good cause, it can be set within 90 days. The respondent also has the option to stipulate or agree that the child can be adjudicated abused and/or neglected. In a stipulation, the respondent agrees that the state has enough evidence to prove the abuse and/or neglect, but he does not want to admit to it outright. In most cases, the stipulation is also made pursuant to Rule 9 of the Wyoming Rules of Juvenile Court. Rule 9 prevents anything the respondent says in a multidisciplinary team meeting or case planning meeting to be used in a criminal case arising out of the same incident. If a stipulation is made and accepted by the juvenile court, the child is adjudicated abused and/or neglected, and the case proceeds to the disposition. If all parties agree, the court can enter a consent decree, which gives the court jurisdiction over the parties and the child. The adjudication of the case is held in abeyance while the respondents work their case plan. If the respondents do what is required of them pursuant to the case plan, the case will be dismissed without an adjudication. If the respondents fail to work the case plan, the proceedings can be reinstated or the consent decree is revoked and the respondent is adjudicated as having abused or neglected the child. A consent decree can be entered with either an admission or a stipulation. If a consent decree is entered and the petition is reinstated, the admission or stipulation is automatically entered on the record. If the consent decree is entered without an admission or stipulation, the state proceeds to the adjudicatory hearing after the petition is reinstated. The consent decree remains in effect for no longer than 6 months, but it can be extended for an additional 6 months if all parties agree. The district or county attorney, the guardian ad litem, and the parents must all agree in order for a consent decree to be entered. The consent decree must be in writing and it must include the case plan. A disposition hearing can be held immediately after the adjudication or admission or within 60 days of the adjudicatory hearing. The court must consider the predisposition report, multidisciplinary team report, case plan, and any other reports or evaluations provided. If it orders a disposition different than the recommendation of the predisposition report or multidisciplinary team report, then the court must cite the specific facts it used to support that decision. The court must also ensure that DFS made reasonable efforts to prevent or eliminate the need for the child's removal from his home. Under most circumstances, the court will not order an out-of-state placement for a child. There are a few exceptions, such as when evidence is presented regarding placement costs at an out-of-state facility versus one in-state, or if an in-state facility is not available or cannot provide adequate treatment. In these cases, the court will state on the record why no in-state placement is available. If the court orders placement of a child at a psychiatric residential treatment facility, there must have been a psychiatric evaluation completed on the child recommending this level of care, and the order cannot state the specific facility or level of care. Orders of disposition remain in effect indefinitely until they are terminated by the court. Orders of disposition will terminate when the child turns 18 unless the court has ordered that care or services continue past that time. 6 months prior to the child's 18th birthday, the court must hold a review hearing to determine whether care or transitional services should continue and for what period of time. All disposition orders must terminate when a child turns 21. Review hearings must be conducted by the court every 6 months, but may occur more frequently. At each review hearing, the court looks at the situation from a number of different perspectives. It determines the health and safety of the child and the continuing necessity for placement. It looks at reunification efforts and whether those efforts are consistent with the case plan. The court determines whether or not the case plan is appropriate, and it looks at the extent to which parties have complied with the case plan. The court also wants to see whether progress has been made toward correcting the causes for removal of the child from his home, and if progress has been made, what is the extent of that progress? Finally, the court wants to know the date that the child is expected to be returned home or placed for adoption or guardianship. Finally, and extremely important to the future of your client, is the permanency hearing. The court must conduct a permanency hearing no later than 12 months after the child's removal from her home and at least every 12 months after that. A permanency hearing is also required within 30 days of a determination by the court that reasonable efforts are not required. A permanency hearing is different than a 12-month review hearing. As a GAL, you should ensure that the proper evidence is presented at a permanency hearing. At the permanency hearing, the court must determine whether reasonable efforts were provided to reunify the family. The court must also determine whether the permanency plan is in the best interest of the child and whether DFS has made reasonable efforts to finalize the permanency plan. A GAL should ensure all court orders accurately reflect the purpose of the hearing. At the permanency hearing, DFS informs the court of the efforts made toward permanency for the child and addresses any other options for permanency. If necessary, DFS will present reasons to exclude permanency as an option. Finally, DFS submits a proposed plan to carry out the placement decision, including specific times for achieving the permanency plan. If a permanency plan other than reunification, adoption, or guardianship is proposed, DFS must present a compelling reason for such plan. When a child has been in foster care under the responsibility of the state for 15 of the most recent 22 months, the state is required to file a petition to terminate parental rights, often abbreviated to TPR. There are a few exceptions to this mandatory rule. The state can choose not to file a petition to terminate parental rights if the child has been in the care of a relative or if there is a compelling reason that termination of parental rights is not in the child's best interest. If DFS has not provided reasonable efforts to return the child to her home, then the state may choose not to file the petition for TPR. As a GAL, it is your duty to ensure hearings occur in a timely manner. Don't rely on your district or county attorney to request hearings. If your client is due for a hearing, request the hearing. The Wyoming Children's Justice Project has created hearing checklists that you can use for each hearing in an abuse or neglect case. There is a long form containing a considerable amount of detail and a short form that can be printed and placed in your file before court. You can find these checklists on the Wyoming State Supreme Court website. A link taking you directly to these forms can be found in the handbook you received with your training materials. Children who are victims of abuse and/or neglect will often exhibit both behavioral and emotional, as well as physical indicators of that abuse or neglect. As you interact with your clients, you must know how to discern differences between normal childhood accidents and intentional, unlawful disregard for a child's health and well-being. Knowing that every case is different and every child is different, a GAL must be perceptive of indicators which could be warning signs of additional abuse or neglect. If you observe unexplained bruising or welts, burns, unexplained fractures or dislocations, or unexplained cuts and abrasions, these could be signs of abuse or neglect other than that which formed the basis for the child being brought into care. If you have reason to suspect additional or varied neglect or abuse, consider consulting an appropriate professional such as a doctor, therapist, or investigator. Your GAL handbook contains detailed lists of indicators of abuse or neglect. While these lists are not exhaustive, they will provide a backdrop for you to consider should you notice anything suspicious. Take the time to review and reflect upon these examples. Be prepared to act if you should see these or other telltale signs in any of your clients. A physically abused child may exhibit many signs of being abused. The child may react strangely to punishment, be wary of adults or other children, or be overly aggressive or withdrawn. Some children might be afraid of their custodian or a family member, or they may be afraid to go home. Others may strive to get attention. Some children may react strangely when physically examined. For example, a child may not be afraid at all of a physical examination, or the child may be overly afraid of an examination. A physically abused child may also exhibit a maturity level either above or below his developmental age. The indicators of sexual abuse can be more difficult to assess and often cannot be confirmed without a thorough physical examination. While we will not list those manifestations here, your GAL handbook includes specific examples of physical signs and behaviors which may indicate sexual abuse. Please take the time to review this information. You should always refer a child who has suffered suspected sexual abuse to the appropriate professional. As a guardian ad litem, you must also be aware of other indicators of abuse and neglect in children. These can range from physical exhibitions and behavioral issues resulting from emotional and psychological abuse to stark examples of physical neglect. A child's response to these types of mistreatment varies from one child to the next, but there are signs which you can uncover when you are aware of what to look for. Rather than providing an exhaustive list of possible specific behaviors here, it is important that you take the time to review your GAL handbook to get a feel for ways in which a child may be communicating the additional abuse or neglect he may have suffered. Keep in mind that the lists are not all-inclusive. You may notice other telling behavior in your particular child client. Don't ignore your instincts if suspect additional problems. Children who have been the victims of maltreatment by their parents or primary caregivers respond to their situations in a number of ways. They may believe that their experiences are unique, or that they are to blame for what has happened to them. They may feel hurt, confused, guilty, or rejected. Often these children don't trust anyone and feel they cannot talk to anyone about what has happened. The consequences or impact of maltreatment are varied and far-reaching. The consequences can vary depending on the gender of the victim, with boys being more likely to externalize the effects of maltreatment, and girls being more likely to internalize maltreatment. One study has found that a history of physical abuse or neglect increased the odds of arrest as a minor or as an adult by 60%. Maltreatment can cause someone to be more likely to struggle with drugs or alcohol and suicide. In addition, victims of maltreatment can experience problems with physical health, missing work due to illness, depressed feelings, and frequent emotional outbursts and conflicts. Another study has found that maltreated children in general were more negative, non-affectionate, and lacked enthusiasm and persistence in age-appropriate tasks. They were more likely to be angry. They showed a lack of self-control and low self-esteem. In the same study, physically abused children were identified by teachers as extremely inattentive, unpopular, aggressive, and overactive. They were more likely to engage in self-destructive and obsessive-compulsive behavior. With all the evidence supporting the effects of maltreatment on a child, history and experience prove that children want to be with their parents, and that statistically they do better when they live with their own parents. Therefore, as you work through a child's case, carefully consider all options. Weigh his safety and welfare against his psychological need to be with his parents, and look for a solution that is truly in the child's best interests. You will need to be aware that oftentimes, the young clients in abuse and neglect cases will be at risk for delinquency and CHINS cases as well. It is not uncommon for an abused and/or neglected child to be habitually truant or runaway, or to have behavior issues that result in a possible delinquency proceeding. You can be involved in these other proceedings upon appointment by the court, and it can be very helpful for the child to have that consistency. Although the child will have his or her own attorney in a delinquency or a CHINS proceeding, you maintain the role of advocating for his best interest. If a situation arises where the child is subject to an abuse or neglect case and a CHINS or a delinquency case at the same time, you can meet with team members and perhaps advocate for only a single case, the one that best suits the needs of the child. Every family and home situation is different in abuse and neglect cases, but several factors are present singly or in combination in almost every confirmed child abuse or neglect case. For example, how parents were cared for in their childhood affects how they care for their own children. A crisis or series of crises in the home can affect a parent's ability to properly parent his or her children. Sometimes a child's behavior may fall short of his parents' expectations, and that will trigger parental anger. Sometimes it is isolation from needed support or intervention from other adults that can lead to abuse or neglect. Normal child development requires parents who can meet the needs of their child, subordinating their own needs for emotional reassurance. Maltreatment can occur whenever a parent's needs overwhelm his or her ability to give a dependent child what the child must have in order to be safe and to develop normally. The early life experience of the caregiver is one of the major indicators of why some parents abuse their children. Some abused children are able to cope as they reach adulthood and never abuse their own children. However, some maltreated children will repeat the cycle. Economic indicators are another important factor. Poverty in the U.S. is associated with physical abuse and neglect more strongly than with sexual abuse. Sexual abuse is more likely to be reported in all socioeconomic classes. Genetics can also play a role in maltreatment in terms of underpinning some other factors such as depression, substance abuse, and mental illness. When a child is removed from her home, immediate and frequent visitation between the child and her parents helps maintain the child's identity and reduces trauma. Visitation also provides insight into parent-child interactions, which could have an influence on future decisions regarding the child's safety. When setting up a visitation plan, avoid the one-size-fits-all cookie-cutter approach, as this may place needless restrictions or barriers on contact and delay reunification. Above all, keep in mind why the child was removed when you are determining a visitation plan. The Adoption Assistance and Child Welfare Act, as well as the Adoption and Safe Family Act, mandates that reasonable efforts be made to reunify children with their parents. In order to be in compliance, a solid visitation plan should be developed immediately so as not to disrupt the parent-child bond and to increase the likelihood of reunification. Of course, in determining reasonable efforts, the child's health and safety is still of paramount concern. Your role as the GAL is to advocate for visitation for your client in the location, frequency, and type that is in your client's best interests. This oftentimes means relying on a counselor or other mental health professional to determine what is best for the child. It is your job to ensure the counselor understands that the law requires visitation as part of reasonable efforts. When establishing a visitation plan, the parties involved should evaluate the needs of the family against safety concerns of the child. The need for supervised visitation is often present, but it should not be an automatic assumption. Typically, there will be a progression from supervised to unsupervised visits. DFS or another organization will supervise visits until the need for supervision no longer exists. When unsupervised visits begin, there may be unannounced drop-ins either from you or from DFS. These unsupervised visits progress to visits without surprise drop-ins, then to overnight and extended visits, and finally to trial home placements. Other specific visitation plans may be formulated when a child has been through a significant trauma, or therapeutic visitation may be required for relationships that need some intervention in order to improve. Oftentimes, while observing a visit between a caregiver and a child, you can pick up on several cues. Look especially for nonverbal cues, as these can be the most telling. For example, if the child will not go to the parent, this should be explored with the aid of a therapist working with the family and the child. It is incumbent upon you to pay close attention to the visitation cues in order to best advocate for the child. When infants and toddlers are involved, you should be especially sensitive to time. It is not good for children to be moved from one caregiver, parent, or foster parent to another for more than a very limited time, generally measured in hours for infants and days for toddlers. Every move has an impact on the child and may cause the child more harm in terms of loss and depression. Careful and thoughtful consideration must be given to each and every move for these very young clients. And as discussed earlier, frequent visitation, pending safety concerns of course, must occur with these young children in order for the attachment and bond to progress between the child and his or her parents. You might consider having visits in the foster home, since the environment is less superficial than a visitation room at DFS. The added benefit to visitation in the foster home is that the foster parents can model their parenting skills for the child's parents. There are levels of out-of-home care that are thought to be less disruptive to children. Before placing a child out of the home, first consider whether the child can be left in the home with or without DFS supervision. If removal is necessary, consider placing the child with a suitable relative or other adult caretaker with whom the child is already familiar. If there is no suitable relative or adult available, then the child should be placed in a foster home. Placements in a residential or psychiatric treatment facility, if deemed necessary, are discussed in other sections of your training. Being familiar with all facets of the abuse and neglect process is critical for a guardian ad litem. Continue to review this section of your handbook periodically to ensure you are fully versed in the process flow, case law, and all aspects of the family dynamics which can have an impact on the child for whom you are advocating.